Mr. President, I come to the floor today to speak in support of legislation I've introduced called the Venue Equity and Non-Uniformity Elimination Act, or the Venue Act. This addresses patent venue reform. Patents are an important part of the economy and are vital to promoting innovation and spurring growth. However, the health of the patent system is at risk. Specifically, there's an ever-increasing problem of frivolous patent lawsuits brought by non-practicing entities, also known as patent trolls. This problem is exacerbated by plaintiffs being able to handpick friendly judicial venues that are otherwise unrelated to the alleged infringement. An article in the Harvard Business Review states that patent trolls cost defendant firms $29 billion per year in direct out-of-pocket costs. And, quote, in aggregate, patent litigation destroys over $60 billion in firm wealth each year, unquote. It's clear that these types of abuses impose substantial costs on the economy and simply cannot be ignored any longer. Additionally, according to a 2013 White House patent report, the bulk of patent troll suits target small and investor-driven companies. This is a real threat to innovation. The Venue Act addresses this issue and ensures that patent cases are litigated where there's a connection to the patent dispute. Under the Venue Act, in order for a case to be properly litigated, it must be brought where either one, the defendant has its principal place of business, or two, the alleged infringement act occurred, or three, where the inventor conducted research and development that led to the patent. In addition to the provisions related to the proper venue, the Venue Act provides a more streamlined avenue for those seeking review of erroneous venue determinations. I believe my legislation strikes a right balance for determining when venue is proper, but I also understand that addressing venue is just one piece of the puzzle when we're talking about overall patent reform. There are a number of ways that patent reform can be achieved, and that's why I support the principles of the Patent Act and believe it goes a long way in combating this growing problem. The Patent Act includes much-needed reforms such as fee shifting, heightened pleading standards, and customer stays that would provide relief to retailers, smaller businesses, and startups that are constantly under assault by these non-practicing entities. I commend Chairman Grassley for ushering that legislation through the Judiciary Committee. However, one piece of that comprehensive package is venue reform. Such a reform was included in the House version of the patent bill. I believe it needs to be added to the Senate bill as well. All one has to do is look at the numbers, and the problem surrounding venues becomes clear. In 2009, 9% of all U.S. patent cases were filed in one particular federal district. 2009, 9%. By comparison, in 2015, that number increased to just over 44%. That's an increase of over 400%. Again, from 9% in 2009 to 44% in 2015. In addition, of the cases brought in that federal district in 2015, 95% of those cases were brought by non-practicing entities. Such a distortion in case distribution is problematic, especially when the venue has no real connection to the alleged infringement at issue. One hope for relief was the Federal Circuit case in T.C. Heartland, but after the court's decision on April 29th, after it declined to impose more stringent venue restrictions in patent cases, it appears that judicial relief will have to wait. Therefore, this decision has only to be made, needs to be made here in Congress. I hope that it will bring renewed attention to patent reform as we move this Venue Act through the Senate. While there are a number of solutions to the overall patent troll problem, venue reform is of utmost importance and must be central to any larger reform effort. I urge my colleagues to support the reforms contained in the Venue Act, and I yield back.